The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. My name is Jeffrey Kinder, and I'm joined this morning by Justice Peter Sachs and Justice Andrew D'Angelo. And this is April 29th, and the case on this morning's for this morning's session via Zoom is Commonwealth versus Joseph Miller, 21P0051. Counsel for the appellant, when you're ready, you may proceed.
Thank you, and may it please the court. William Driscoll for Joseph Miller. This case is governed by Ware and Rhodes. In Ware, the court found that the police officer's trial testimony did not comport with his police reports. In other words, he claimed that the defendant was at a Dunkin' Donuts, so he must have been one of the shooters in the crime because there were witnesses that saw the shooters run towards Dunkin' Donuts and get in the car to drive away. Well, none of that was truthful according to his police reports, which the Commonwealth used to examine him. Here, we had a voir dire of the Commonwealth's expert, gun expert, where he gave completely different answers to what he told the jury. So
how do we know that, Mr. Driscoll, how do we know that what his trial testimony was false and what he said during voir dire was true, which seems to be your position and assumption?
With all due respect, the jury heard only what was heard during trial. So they assumed it was correct. So for that reason, I'm presuming it is also correct. The jury had no reason to.
Your assertion is that the Commonwealth has knowingly offered or knew or should have known that it was offering blatantly false testimony. What evidence do you have that his trial testimony was false?
Only his voir dire testimony. And the reason for voir dire was because defense counsel requested voir dire on his expert ability because he had never testified in court before. No CV was ever provided to defense counsel, and she did not think that he was qualified. So voir dire was to qualify him for the first time in being an expert for firearms.
So he states his qualifications at voir dire. For whatever reason, when he's asked about those qualifications at trial, he states greater qualifications. He's certified more firearms as operable. He's testified as an expert witness more times. What is the problem with that if what he said at trial is true? I mean, if the judge qualified him based on what he heard during voir dire, you're not suggesting that once the judge heard he was more qualified, the judge might not have qualified him, are you?
No, not at all. Our case law tells us that when a judge qualifies an expert, he's qualified as an expert. But now it's up to the jury to decide the qualifications and his credibility and enter that into their mix when deciding the case.
So unless that testimony is shown to be false, you don't really have a claim here, do you? The testimony to the jury.
I have to say that it would turn to, did he lie before or did he lie after? I mean,
right. Can we resolve that on this record?
On this record, he says he had never testified in court before. To the judge and to the jury, he says, I'm experienced because I have 20 times testifying.
There's an obvious discrepancy there. He also has there's a signed certification in the record where he says that he's testified as an expert before. But I don't think we can tell, and maybe you'll convince me otherwise, or ADA Glennon, that I don't think we can tell which version of his qualifications is accurate on this record. And my fundamental question is this something that, if it's going to be pursued, would need to be pursued through a motion for new trial?
I would say no, because the Commonwealth solidified the impact of his statement that he's been an expert 20 times in court before, 400 guns tested versus 150. They solidified that in closing argument. That was an important part of their closing, saying that he's a very experienced firearms expert.
But if that was accurate, then there's no problem with the Commonwealth emphasizing it in closing. Would you agree?
I would agree with that. However, the Commonwealth has an affirmative duty to correct the record when they know it is incorrect. So they should have corrected it during voir dire so that defense counsel would at least have a heads up.
Well, is there anything in the record indicating the Commonwealth knew or should have known that what he said about his qualifications during voir dire was incorrect?
Well, defense counsel didn't know because never received
I'm asking about the Commonwealth. Is there any evidence on this record that the Commonwealth knew? Okay, so does this have to be pursued, if at all, through a motion for new trial rather than on a direct appeal?
On a motion for a new trial, the question is going to come down to, are we going to have access to all of the Commonwealth's records on this individual? And if so, why wasn't it turned over to defense counsel before trial? So there we have another error.
So Attorney Driscoll, is your position that it doesn't matter which one, either the voir dire or the trial testimony, was incorrect? At one of those junctures, the Commonwealth had an obligation to tell the fact finder that one of the versions was incorrect?
Yes. And that comes straight out of where, as David Lowy said, the error warranting reversal goes to the heart of the Commonwealth's duty to do justice.
And Mr. Driscoll, what do we do with the fact that not only did trial counsel not bring the discrepancy between the trial testimony and the voir dire testimony to the judge's attention in the form of an objection, but he used it to his advantage during cross-examination?
I don't believe he used it to his advantage. He used it to attack the credibility of the witness in a different way. You've testified in court on X number of weapons, and every single time you were the Commonwealth's witness, and every single time you found a legal firearm.
Which is a point he would not have been able to make if the expert had never testified in court as an expert, correct?
Correct.
So he used it to his advantage.
The expert used it to his advantage, that he's very good at finding firearms compliant with the statute.
Sorry, counsel. What obligation does the Commonwealth have to bring it to the attention of the judge when the judge heard it? It's not like it was Judge A heard the voir dire and Judge B heard the trial. It was the same judge. So the judge knew the voir dire testimony of the trooper and then knew the trial testimony. So what should we do with that the judge also was sitting there and heard that and didn't bring it up?
Well, Ware cites the U.S. Supreme Court case of Gigliano that says, whether by negligence or design, the duty of the prosecutor is to correct false testimony. They must have known at the time of voir dire their experts' qualifications. So either they knew it was wrong then, or they knew it was wrong during trial.
Well, it would certainly be good practice to know what your experts' qualifications are before the voir dire, but is there evidence that the Commonwealth knew that?
There's
maybe
nothing
the Commonwealth, maybe the trial ADA fell down on the job here and didn't know and didn't notice the discrepancy. But can we assume that what was said at voir dire is correct and what was said at trial was incorrect?
We can assume that because the prosecutor, these are the prosecutor's questions at voir dire, and they're the exact same questions asked during trial by the same prosecutor just minutes or hours away. It's incomprehensible in my mind that they would not notice the difference between I have never testified in court before today and I have testified in court as an expert approximately 20 times.
It does seem incomprehensible. Isn't it just as incomprehensible to defense counsel?
It is, but defense counsel has absolutely no burden whatsoever to bring this up.
Yeah. Defense counsel, I suppose, could have said, Trooper Medeiros, you said you've testified as an expert 20 times. Didn't you just testify an hour and a half ago in a hearing before the jury came out that you'd never testified as an expert before? Was there anything barring defense counsel from asking that question?
No, there is not.
Pretty
However,
effective impeachment, wouldn't you think?
well, then we have the expert saying, I believe I testified the same way as I did before. There is no transcript of voir dire. There is nothing on the record to say, well, let me impeach you with the question and answer session. That would be totally up in the air where whether the judge or the expert, judge would remember, or the expert would just say, I believe my testimony was the same. Basically, prove me wrong. There's no transcript because it just happened. It's not the judge's duty either. It is clearly on the prosecutor, according to Ware and Supreme Court precedents. And also under the Supreme Court, NAPU, it doesn't matter whether the falsehood bears on the witness's credibility or directly on the defendant's guilt. A lie is a lie no matter what the subject. The prosecutor's duty is to correct. Here, the prosecutor did nothing to correct in either end.
Do you have any case saying that the prosecutor has a duty to correct a discrepancy between pretrial testimony and trial testimony, absent evidence that the prosecutor knew that trial testimony was false? Is a discrepancy alone enough to trigger a duty on the part of the prosecutor?
No, and that is discussed in Ware. In Ware, a discrepancy that is arguable is not correctable. So if it was a discrepancy between two witnesses said it was red, my witness says it's blue.
Well, but here we have a little different situation. We have, I think, what's quite close to an inarguable discrepancy, where he says, I've never testified before as an expert, and then he says, I've testified 20 times. Do you have any case that says that that sort of discrepancy, and I'm not purporting to quote from the transcript, but something close to that, any case saying that kind of discrepancy must be explored and cleared up somehow by the prosecution?
I do not. All I have is Ware and Supreme Court cited within, stating that it's the prosecutor's duty to know and to correct knowingly false information that's provided by their witness. That in no way is it on the defendant to breach the topic whatsoever. Particularly here where it goes to the central issue in the Commonwealth's case. Mr. Fortune was found guilty of possessing a firearm. The question with this expert was it a firearm? His credibility was 100% of this case.
Counsel, you're running low on time, and I'd like to hear about the second part of your argument, which is that the sufficiency regarding the firearm being a working firearm was not enough for the jury to convict on.
Yes, Rhodes covers that case, and it also discussed Bartholomew. It was not a simple fix to get this gun that would not index with a pull of a trigger. He had to actually move the cylinder in direct aim with the barrel, which is a very fine point. It's, as they said in Rhodes, as with a television set, it's one thing to know how to use a weapon, but few can fix one. So if it was not a simple, as Bartholomew said, is quoted in Rhodes, if it's not easily replaced standard slight repairment, then that can be done by a layperson, then it cannot be fixed. Here you needed an expert who had no testimony about what the defect actually was, only that he took a defective gun and aligned a cylinder. We don't know what was wrong with the gun. He didn't know what was wrong with the gun. So how do we know that that was such a slight defect that a layperson or Mr. Miller would have the know-how of fixing without the expertise of a ballistician?
Mr. Driscoll, I see your time is up. Are there further questions from the panel? Seeing none, thank you, Mr. Driscoll. Ms. Glennon, when you're ready.
May it please the court, Stephanie Glennon on behalf of the Commonwealth. Your Honor, I just like to briefly note the context for the requested by defense counsel on literally the morning of trial as impanelment was about to begin. That was on February 1st, 2017, when defense counsel chose to wait until then to request a Daubert-Lanigan hearing, just as impanelment was about to begin. And that effectively precluded the process. So the defense counsel knew that she was anticipating a Daubert hearing and knew to prepare for that. But that effectively precluded the prosecutor and the witness from preparing for that. So I think that's important to the context here and casts some light on why Trooper Medeiros would have exhibited some confusion about, and you'll note at the end when trial counsel is arguing to the judge, she describes it as a hearing that he
Ms.
may
Glennon,
well have been.
Ms. Glennon, if I could interrupt for a moment, whether there was a voir dire anticipated or not, if you were going to call a witness that you're going to propose as an expert, typically there would be some preparation for that expert's qualifications. And it appeared here that there were not.
No, Your Honor, I wouldn't say that at all. Both counsel had an opportunity, unfettered opportunity to explore, as defense counsel as well, the qualifications of the witness. But in the terms of a Daubert hearing, that could unquestionably be a first for a ballistician. It's an age-old forensic practice, and ordinarily a Daubert hearing goes to although qualifications are relevant, that is not the whole part of a Daubert hearing. But what I'm saying is that
except that in the areas we're focused on today, which is how many times has he testified and how many firearms has he certified, those would be standard questions to lay any foundation for expert testimony.
Absolutely, Your Honor.
So I guess I didn't understand the significance of the surprise Daubert-Lanigan request.
I don't disagree with that. I'm just saying that requesting what I'm saying is that for why and trial counsel's description of it as opposed to trial, as it may well have been that Trooper Medeiros was referring to never having testified. Certainly have been, but the point for new trial, to clarify the point, had it been significant to clarify, and he certainly, it bears the burden here, in the absence of any objection and in the absence of any claim from the attorneys in the room, from his own counsel, that there was a lie at trial. In the absence of that, he bears the burden of showing a substantial risk of a miscarriage of justice. That includes error, that includes prejudice, that includes his proving that in the context of the whole trial, one can reasonably conclude that this could have materially influenced the verdict, and that the absence of that claim wasn't a reasonable tactical decision.
Ms. Lennon, at least on the cold record,
Justice Kinder and Justice Sachs, I'm having a lot of issues hearing Attorney Glennon's argument. Are you as well?
I have for the last for the last minute anyway.
And
Would you like me to pause it and the time would be 10 minutes and then we could start again once we get the audio fixed?
Yeah, why don't we do that? Matt, can you hear me?
Yes, I can.
All right, are we suspending? Is that what you were suggesting?
Yes. I'm just going to put her back in the waiting room and then I'm going to chat with her to see if she can fix her audio.
All right.
We're still streaming.
Yes.
Yes. Attorney Driscoll, were you able to hear the argument?
No, she was breaking in and out as if she was underwater.
All right, thank you.
Good afternoon, Attorney Glennon.
Yes.
You're having an issue with your audio. Is there the audio and video is jumpy?
I am not having that issue on my end.
We're having it here.
Um,
I'm going to put
For
you
the
in the
last-
waiting room again, and could you log out and then log back in again?
I will try that. Yes.
Okay, I'm going to put you back in the waiting room. Hello.
Hello.
Yeah.
Is this better?
We're still
Yes.
having difficulty hearing you.
Yeah,
By telephone, or should
I am
start
talking
all
to her.
over
Yeah,
again?
it's terrible.
Do you need to perhaps to move to a spot with a better, more stable Wi-Fi
Move
connection?
closer to the move closer to the computer.
I am 2 inches from the computer.
But I'm saying, is your computer in a location that has a good Wi-Fi connection?
Yes. Yes, it was, yeah, it was, and it was fine until the last minute.
You actually
She
seem
appears to be
better now.
Should I try to proceed, Your Honor?
Hold on a second, please. All right, thanks, Tom. Yes, you were at 10 minutes.
Can you hear me now?
Yes.
Okay.
All right, hold on.
I'm going to put the clock back on. Hold on. All right, you may proceed.
All right, thank you, Your Honor. I'll try to get back to where I was. I'm not sure what you didn't hear. It's the Commonwealth's position that the defendant who elected not to bring a motion for new trial has not met his burden to show that any trial testimony was factually false. And trial counsel, in fact, used cross-examination, who was obviously there in the room, equally heard everything the prosecutor did. She used cross-examination to clarify both points to her reasonable tactical advantage. First, at best for the defendant, I would say there were arguable then inconsistencies between two of Trooper Medeiros' answers at the Daubert hearing, and neither of them was central to the case in any way. The number of times an expert had testified, or the number of career test firings he had done, and I'll detail those a little bit more. But to the extent that either of those trial either of those trial remarks were of any import to the defense, trial counsel strategically addressed both of them. And that's very important, because the fourth prong of a showing of the substantial risk of a miscarriage of justice requires the defendant to demonstrate that the absence of a claim of error, available claim of error by his counsel at trial, was not a reasonable tactical decision. And on this record, he has not and cannot do that. First of all, trial counsel clarified that the estimation of 400 test firings applied to the entire universe of the test firings Trooper Medeiros had done, not just the weapons he himself had certified in his 2.5 years as a qualified firearms examiner, himself able to certify a weapon
I'm
that
not
he
quite,
had test fired.
Attorney
He
Glenn,
also
I'm not quite understanding that point, because the question that the ADA put to the trooper in voir dire was almost identically phrased to the question at trial about how many, he has personally test fired firearms to certify them as functioning and operable under Massachusetts law. And the question was, how many times have you done that?
Correct, Your Honor. He's I think the purported inconsistency here is that what is susceptible, again, a motion for a new trial would certainly have been helpful had this been of any import at trial. And I would suggest it was the larger number that trial counsel used, because that served her strategic point and she conceded its accuracy. So I would suggest looking at his testimony, and again, trial counsel heard the same testimony and was free to explore and correct anything, had anything actually needed correcting. But I think his testimony suggests that the 150 number goes to the ones he had personally both test fired and certified. And the 400 number was something that she expressly cross-examined him about and made clear that he was talking about his career test firings. So that's a 2.5 year period as a certified firearms examiner, and the 2 year period of apprenticeship during which he testified in the same unit. He was also conducting more and more test firings as his apprenticeship progressed. But the entire strategic point of the large number that trial counsel sought to elicit and successfully elicited again at trial was to underscore for it's the argument my brother just made, to underscore the relative rarity of a manual alignment of the barrel. So the 400 number is the one she reasonably tactically stressed the truth of, and there's certainly no showing by the defendant that it was false that he had engaged in 400 career test firings. But the strategic point again is, and this goes to the fourth prong of showing a substantial risk of a miscarriage of justice, is the defendant's burden to prove that the absence of an objection by his counsel, who heard all of this, who cross-examined the witness twice, was not a reasonable tactical decision. The defense also similarly tactically underscored the fact, certainly the defendant has not challenged it as a fact, that he had indeed testified as a trial expert before. He may well not have testified at a Daubert hearing or any number of other proceedings before, but he clearly had testified. There's no basis for finding it false that he had testified as a trial expert before. It was in his certification, in the certification that the defense had and cross-examined him with before trial. It was the entire point, again, was a strategic and tactical one for the defense that conceded the truth of the trial testimony. If they diverged, once again, her tactical approach stressed the uncontested truth of what he said at trial, and that he had previously testified, because she wanted to make the point, and in service of the defense favoring inference of police bias, which was also the basis for her seeking to impeach him, that he had always testified for the Commonwealth to the same opinion on operability, that it was reflexive for him as a police officer, essentially. So there's no way it can be said either that this was false, either that there was error, or that it could have materially influenced the verdict, because again, it's the number, it's not his opinion in this case. It's about whether this was operable. It's the number of times he testified is of no evident assistance to the defendant's cause. The only assistance to the defendant's cause, which his counsel wanted to draw out, explicitly wanted to draw out, was that he always testified in court on behalf of the Commonwealth and for a conclusion of operability. Both points at trial were swiftly, strategically addressed by counsel, and I'll go back to which reiterated inconsistent testimony that any particular counsel is right there. She heard everything the prosecutor heard. She had the information the prosecutor had, and she drew this out, and she stressed the truth and argued the truth of what he testified to at trial, and has not since trial challenged factually by going back to the trial judge or presenting any evidence. It would have been a pretty easy matter to go back and to bring a motion for a new trial if there was any credible basis for seeking to show that Trooper Medeiros had never testified at a trial before. That would have been pretty easy to prove, but it also would have been beside the point here. Ultimately, it could not have materially influenced the verdict. If we're talking about even assuming that he hadn't testified 20 times, I think my brother's argument concedes that at best that would be impeachment, and that additional impeachment doesn't ordinarily get a new trial, and it certainly ought not to in this case where there's no objection.
But where this witness's testimony was the sole evidence that it was an operable firearm, isn't his credibility essential to the conviction?
His credibility is always significant.
Isn't his testimony more? Isn't his credibility more significant in this case than if there were a dozen other witnesses who said, "I saw the gun firing"?
I'm not sure it can be compared to that way. Every witness's credibility is at issue. However, there's nothing to say, there is no showing that the defendant is required to make to show a substantial risk of miscarriage of justice, that he falsely testified, that he had testified as a trial expert before. The defendant simply hasn't made that threshold showing.
Counsel, was the trooper's certificate admitted into evidence at trial?
No, it wasn't. But trial counsel had it with her, cross-examined him with relation to it. So she had it. And she had it at the Daubert hearing as well, and cross-examined him with that in hand.
And that certificate specifically stated that the trooper had been previously qualified as a ballistic expert in the district and superior courts, correct?
Yes, Your Honor, and trial counsel certainly did not claim that was error or a falsity, and that should be in the Commonwealth Supplemental Appendix.
Thank you, Ms. Glennon. I see your time has expired.
Oh, thank you, Your Honor.
All right, thank you very much for your argument, both of you.